Good morning. This is Judge Alyssa Perez. Resuming the criminal docket in the 210th District Court for January 31st, 2023. All matters being heard today are being heard in accordance with all emergency orders and directives regarding COVID-19. In addition to that, we are streaming all matters live via YouTube for public viewing. Mr. Marufo, would you call our next case, please?
Second on page 10, Judge. On page 16, excuse me.
Okay, go ahead.
In cause number 2014-0D01785, State of Texas versus Anthony Smith. Announcement of counsel, please.
Eliana Elizalde, on behalf of the state is ready.
Ruben Ortiz, on behalf of Mr. Smith, we're ready also, Judge.
And Mr. Smith is appearing remotely from the jail annex. We are scheduled for a bond hearing today. I think, Mr. Ortiz, this one has been kind of a quick turnaround. I feel like when we had our last probation status hearing, it might have just been last week. And so I am familiar with Mr. Smith. You're more than welcome to proceed on your bond hearing, but I can tell you I've already kind of thought about his probation case. So you tell me how you want to proceed.
So Judge, just so you know a little bit about his case, I don't know if you know this, but I think there was some miscommunication as to how many misses he had, Judge. And I know you got really upset with him. I always, and rightfully so. However, Judge, so my understanding is that he was told by his probation officer, Dorothy Reyes, that he had missed a session, I think. Mm-hmm. Then he had another probation officer by the name of Reina Ramos and stated he was 3 misses. So there was a confusion to how many times he missed. He claims he has form records, Judge, and text to prove that little mishap, or I guess that, Your Honor.
Let me ask you, Mr. Ortiz, when you're talking about misses, do you mean just failures to report or the times he was dropped from treatment?
You know, Judge, I want to say that he missed some sessions, and I thought it was due to some classes you were really upset about, Your Honor. And I know that this sounds like a really ugly case, right? But I think this was a case, Judge. I mean, I didn't represent him, but it's one of those, I think it was one of those cases, where it was a consensual relationship case. It just happened to be more than 3 years, I think, apart is what it was, Your Honor. Mm-hmm. So I haven't seen that other case, Judge, but it's my understanding that's the type of case we're dealing with.
Right.
You know, versus like, the real type of case, you know what I'm talking about? What I mean by that, by that, Judge, is that I think we all know that there's a difference, I think, well, not according to the law, but I think factually there's a difference, between that type of situation and the other type of situation where it's a small child and or something like that, Your Honor. Not a type of case like this. I think he was told he missed 3 appointments, and that's why he was, but I don't know which kind of appointments now that I think about it, Judge.
So let me tell you a little bit about what I know about your client, and Ms. Ramos, just go ahead and correct me. Part of the reason we had some, Ms. Ramos, I think, inherited Mr. Smith's case from, and he may have gone through more than 2, maybe 3 probation officers. And over the course of that time, there has been some very inconsistent compliance, meaning there's been non-compliance. So I think he's been dropped at least twice, maybe 3 times. I got to go back because I read this earlier this morning.
3 times, Your Honor.
3 times. So once in like 2020 and then in 2022. And they were.
And that is from EHN, Judge? EHN?
No, that's just from the probation specialized treatment. And those were over the course of multiple years. So the first one is like in 2020, and then he gets dropped twice in 2022. And it's for a combination of reasons, financial and not going. So there's attendance and financial. So, there's always this thing about, well, if they don't have the resources, we look at that. It's also just not showing up. Then in addition to that, at the end of the year, and I think maybe into 2023, we have legit failures to report to probation. Okay. Now it's in coming in on that, on the probation status hearing, that then I find out that we have some really inconsistent supervision and no notice to the court, although your client has been on probation for many years, right? I think he went on probation in 2015, we're 2023, and all of a sudden we find out there's these huge chunks of just like, meh. Okay, and I'm not saying that's your client. Part of the frustration was with probation.
Got it.
And so, however, with all of that frustration, we still have some non-compliance. So yes, your characterization is correct. I was very upset. I was very upset because
Rightfully so. I mean, he's
we're
you know,
not seeing that compliance, and we're not
Right.
seeing him being supervised properly.
got it.
Now,
Got it.
that's why I sent out the bench warrant. I
Right.
certainly wanted to get Mr. Smith's attention because for whatever lax supervision there's been, that ends now. But I also think, Mr. Ortiz, that's not an excuse for his non-compliance. So I think there
Right.
needs to be a sanction.
Yes, Your
So
Honor.
the probation recommendation is to continue him on supervision, re-enroll him in treatment. I agree with that, but I still believe there's an additional sanction here because we do have the failures to report. And for whatever reason that we had lacked attendance, you know, I'm happy to do a financial screen if money's an issue. I don't know if he's working. Billy, if he hired you, maybe he has some resources. I don't know his situation fully. But what I'll say is this, we're gonna give him a jail commitment. Okay? I don't know if he's working. I don't have a problem, Mr. Ortiz. He is working,
Yes, Judge.
doing it work release, but he's gonna give me 30 days. Okay?
Yes, Your Honor. Just so you
He's
know,
on-
Judge,
Uh-huh,
he
go
is,
ahead.
he is working at Apple One Staffing, and he's been there since, I believe, October, Your Honor, of 2022. Prior to that, he was working at Vapolocity, I think, since 2019.
So I think this is
He-
gonna be
yeah.
the right time to get everybody on the same page. Okay? That is gonna come, my thing is, we're gonna do 30 days, we're gonna get him on track. We're gonna find out in 60 days, do a probation status review that he's enrolled in treatment and is doing everything and doing the reporting and making sure that everybody's doing their part. And then if we're on track, so be it. Mr. Smith is now aware that if I find out from probation that he's not on track, because everybody knows now, probation's well aware, the supervision needs to be happening the way it's supposed to be happening, that if we
Yes,
have a fault on his part, he knows where he's gonna end up. Okay?
Fair enough, Your Honor.
So that's why I was saying, I hear you on the bond, but really that's where I am.
Okay, no, that's,
Okay? So
Yes, Your Honor.
if everybody, I see your client nodding, I don't know if you need to speak with him. I'm happy to
Oh.
just do a release, and I don't know if we had a motion at this time. Did we already have a motion, Ms. Elizalde? I don't remember.
We do not have a motion, Your Honor, and I don't see a violation notice on portal or in my email, so
Okay,
that's the reason why.
so for my purposes, we're starting from scratch. We're gonna do, are there any other, I mean, I'm gonna have some deadlines. I don't know how long it takes, Ms. Ramos, but I know in the 60-day probation status review that we're going to do, he better already be enrolled, all those things. He better be on track with everything. We will do a financial assessment because I do see that he has some outstanding financials, right? He's got a lot of community service to do. So what I need to see from you, Mr. Smith, is you need to actually do your probation diligently.
Yes,
Okay,
ma'am.
that means get on community service. If you're working, you better be paying towards your fees, but we will do a financial to make sure
Yes,
he's
ma'am.
got the ability to pay. And so we'll come back in 60 days.
May I
So-
say something, ma'am?
No, I don't think you should right now, unless you need to talk to your attorney.
Okay, yes, ma'am.
Mr.
Judge,
Ortiz,
would that be work release or would that be?
I'm happy to do it work release. I think that's the best way to do it because you know it's gonna take a lot longer.
Forever, yes.
Yeah. So I will expect, we're gonna go ahead and release him today. Okay,
Yes, Your Honor.
He can start doing.
you.
right
Appreciate
more than
that.
31st. He can start doing his work release. What are your work hours, Mr. Smith?
Before I came in here, I was working from 7:30 to 3:30 Monday through Friday.
Okay, so I'm gonna have him report next week, Mr. Ortiz. So that is going to be beginning the 6th of February. For now, I'm gonna go based on what the work hours he's provided today. So he will have to turn himself in. We'll do 8 p.m. to 5 a.m. every day until we get our 30 days done. Mr. Ortiz, I'm gonna rely on you to get with your client. And if that is somehow different, you better let me know before Monday because the jail's gonna be expecting it. Okay? Is that reasonable?
Mr. Smith, you're okay with that schedule? Because we don't have much time between now and then.
Yes, sir. I am okay. If I have any changes, I will make sure that I reach out to you and let you know. The only thing is I'm not sure if I still have that specific job that I had before. But if I don't, I can go immediately tomorrow to a place called Elwood Staffing, and I've told me in the past already that they'll take me and make me start next day on work.
Okay, so then I expect you to be there on Monday, 8 p.m.
Yes,
Okay?
ma'am.
All right, Mr. Ortiz, anything else?
Nothing further, Your Honor.
Thank you very much. I'll get. the
Judge, thank you.
appropriate-
May I be excused?
You may, Ms. Ramos, thank you very much.
Thank you, Your Honor.
I know you're taking the brunt of all these cases. All right,
Thank you, Your Honor.
is that all we have at downtown?
Yes, ma'am. We only had one today.
Thank you.
Yes, ma'am.
Who's next?
Bottom of page 14, Judge. Next, may we have Herrera?
Herrera Keila?
Yes, sir.
Hi, Mr. Abrar.
Good afternoon, Judge. How's it going?
I'm all right. How are you doing?
Good to see you, Judge. I'm good.
Good to see you too. What's the bond on Miss Herrera? Hi, Miss Herrera.
Hi.
I believe it's 10,000.
I'm sorry?
Judge, I believe it's 10,000 cash order.
Okay, go ahead and call it, Mr. Mono.
In cause number 2023-0D00109, State of Texas versus Kayla Guadalupe Herrera. Announcement of council, please.
Eliana Elizalde, for the state is ready.
Adi Faber for Miss Herrera.
And Miss Herrera is appearing remotely from the jail annex. We're set for a bond hearing. Mr. Abrar, you may proceed.
Thank you, Your Honor. Judge, Miss Herrera does not have a criminal history. He doesn't, as far as I know, that she doesn't have any convictions on her record. She's 22 years old. She is going to Southwest Carrier College, and she's studying medical billing. And Judge, this incident had happened between her and her mother, Miss Maria Patlan. And during the investigation of this incident, the mother, there was a video that was observed by the police department where it was shown that the victim, the mother, was actually breaking down her door where she was inside, and she was telling the mother to go away and not come in. And there is also allegation as to our client, Ms. Herrera, took a knife, and she stated, the mother stated that she felt a poke. She stated that she didn't feel any pain, but she feared for her life. But when the police officers actually asked for any pictures, the mother had denied. And mother also refused to give a written statement on this case as well. And
I'm
Judge,
sorry, mother denied what? Denied allowing
denied pictures.
take pictures? Okay.
That's correct, Judge. Take pictures, and there was no blood or any allegations as to that on the police report that she was bleeding or anything to that regard. She also refused a written statement. There was another individual, I believe it was my client's stepfather, who had corroborated, saying that, okay, this was this argument that was going on. It was over some clothing that was at the living room, which belonged to my client. But there were pictures taken of the door of my client's room, and the door was broken down where the mother was trying to get in, and she goes in and I believe takes out my client's phone. So, Judge, the problem in this situation is that Judge, my client told us that her grandparents live in Sunland Park, New Mexico, and she can go over there and she can reside with them. And if you even look at her pretrial report, her risk level is only 2. And I think the report also stated that there was 91% of court appearance on her behalf. So Judge, a very, very low risk defendant, doesn't have any criminal convictions as far as I know. She does not have any money at all because she's a student and unemployed. And she wasn't able to give us any phone numbers or anything like that where we'll be able to reach out to a friend or the grandparents to verify the fact that whether they can post any amount of bond at all. So Judge, and that's the situation we're in. And without getting the lowest amount of bond possible, she won't be able to get out until the resolution of the case.
Okay. Ms. Elizalde?
Judge, for history, what I have is we do have a juvenile record for a possession case. That's in 2017, which probation was modified or extended. An evading, which is dismissed in 18. A criminal mischief, which was dismissed in 2021. An assault family violence, which was dismissed in 2021. So I get that there's no conviction, but there are certainly indications that there's some problems here. As to the facts for the case, officers were dispatched on a domestic incident. Upon arrival, they spoke to the defendant first. Defendant stated that she and mother had a verbal argument over laundry. CW was banging on the door, knocked the door down, and demanded she pick it up. Defendant recorded this portion of the incident, and that's what she said happened. They then talked to the CW, who is the mother, and she stated that defendant was told to pick up her belongings. She went upstairs to her room and locked the door. CW went to bang on the door. She took defendant's phone, and as she was coming down the stairs, the defendant poked her on the left side of the abdomen area with a knife. She did say she feared for her life, and stepfather did witness the incident and gave the same version of events, but didn't see the poke. At this point, defendant then changes her story somewhat. She states that mother broke down the phone, grabbed a knife and put it in her. She said she grabbed a knife and she put it in the pocket, and she continued to record mother going down the stairs. She says she did not poke, but did throw the knife back at the bedroom. She showed video to officers where it shows the defendant grabbing the knife as CW is walking away, and CW did have a scratch on the left abdomen. I would like to speak to CW in terms of the recommendation, and also Mr. Abraj said that we don't have a verified contact information for grandparents or where she would be staying. But I do find the nature of the incident to be concerning, and that assault family violence, we do have some history that which it was dismissed. We do believe that bond is reasonable at this time, and we would object modification.
And Judge, if the court will allow me to respond.
Yes, sir.
And Judge, just to respond to that, this video that was provided by my client to the police. It wasn't the mother who recorded it. She gave her cell phone to the cops. She gave the incident, how it had went down, that the mother was the one who was breaking down the door. And it was shown on that video, that mother coming in to that room where she's at. And she admits to the police that, yes, she grabbed a knife. And she's the one who provided this video to the police, Your Honor. There was no deception on her part as to cooperating with to the police, but on the contrary, the complaining witness refused pictures, and she also refused her written statement on this regard. And just about the prior history, they have been dismissed, Judge, and we are requesting the court not to take those into consideration at all.
Okay, I'm going to go ahead and, well, I'm not going to reduce the bond, but I am going to split it. I'm going to split it 2,500 cash surety, 7,500 PR bond. She's going to be reporting monthly. She's to have, those are, it's mom and was dad involved at all?
Stepfather.
Stepfather
is the witness, Your Honor.
Okay, so no offensive contact with the complainant. She's not to be anywhere near the home, the residence of her mother, so stay 200 feet away from that. She'll report, did I say report monthly? She's going to be subject to testing. We'll allow her to reside with, is it grandparents in Sunland Park? But she must maintain that residence. You may not change that residence without court permission. Obviously, commit no new offenses. Subject to testing. I didn't look, let me see, hold on. No, mental concerns. What am I missing, Miss Elizalde? Am I missing anything?
I don't believe so, Judge.
No, I think we have the reporting. Oh, we'll do a curfew from 10 p.m. to 6 a.m. unless she is working or going to school. I don't see a trial track here, so we'll get you squared away with a trial track in the event you need to come to the court for anything outside of those settings. Please file your motion and request your hearing. Okay,
Thank you, Your Honor.
thank you very much. Who's
Permission to be
next?
excused, Judge.
Yes, sir. Thank you.
Staying on page 14, Judge. Annex, may we have Michael Esparza Alvarez?
Good afternoon, Your Honor.
Good afternoon, Mr. Barra.
And Your Honor, we had been trying to access either portal or otherwise try to get to the motion to revoke or at least a violation affidavit, Judge, and hadn't been able to.
Yeah, I don't think, let me see if I can look it up. Oh God, this report is really big. Is that Mr. Esparza? Okay, go ahead.
Because number 2019 0D0 5117, State of Texas versus Michael Esparza Alvarez. Announcement of council, please.
Eliana Elizalde for the state is ready.
All right, Parra, Your Honor, for Mr. Alvarez, also ready.
And defendant is appearing from the jail annex remotely. We are scheduled today for a probation status hearing. I apologize here. This is not the report I thought I had seen. Let me look at it. Ms. Carla, are you covering this one?
Yes, Your Honor.
Can you give me an update on Mr. Esparza?
Yes, Your Honor. The reason Mr. Esparza is in custody, it was due to you requested probation to get a bench warrant. The last report, DWI's reports that were submitted to you, Your Honor, back in December, it came to the court's attention that Mr. Esparza does have active warrants, traffic.
Right, he's been driving. Mhm.
And you ordered the bench warrant and he's been detained as of January 11th.
Mhm.
To be sure, Ms. Pineda, did he have the interlock on him when he's driving? Did he have it at that time? Was he blowing into it during those periods?
He doesn't have the interlock, Mr. Parra. He's not allowed to drive, as per the court. He does have the mobile unit, the portable unit. But
Understood.
yeah, he's not supposed to be driving.
Is this the first time we've found violations on him, Ms. Pineda?
Your
Trying
Honor,
to see.
back in March, there was an admonishment hearing as well, March of
Mhm.
2022. Let me just double check.
You got 20 days, ACOF for a total of 30, released. He did 30 days of condition. I lowered his fees. I told him not to mess up on the monitor, which, do we have any new violations on the monitor? Is it just the driving?
No, Your Honor, it was just the traffic warrant, the traffic ticket, I'm sorry. And as per the officer's report, no, there was just a skip test, but there are no violations.
Does he have a valid driver's license, Mr. Parra?
Your Honor, I'm not aware of that, but I can get you an answer, Judge.
Okay.
Mr. Alvarez, do you have a valid driver's license? Is it suspended?
It's suspended at the moment of traffic violations.
Okay,
When is he supposed to term, Carla? Let me see.
that's something I
2024?
can work, Judge. Andy. Sorry, Judge.
Yeah, well, I just don't, he doesn't follow rules, Mr. Parra, and he's a DWI third, and he's got initially the monitor and now the driving.
Yes,
I
Judge.
mean, those, like, if there were two things that you're supposed to do right, Mr. Esparza, it's those two. And you had already been warned.
Your Honor, he's up to January
uh-huh.
15th, 2024.
I know.
I'm sure.
Your Honor,
Yes, ma'am.
I apologize. The admonishment hearing was back on April 13, 2022.
Mhm.
April 12th, sorry. And it was due to excessive monitor violations.
Right.
And Your Honor, of course, I would like to point out again that he was compliant with respect to at least the machine side of things thereafter, Judge. I regret that he's out driving, and I understand it's a very serious component of the probation conditions, Judge, but would be much more concerned if there were some violations in terms of alcohol. And I think that would show that he's not only taking it more seriously, but is also showing some progress, Your Honor. And he's been in custody for 21 days, Judge. I would ask that the court treat it as a commitment or otherwise consider perhaps an extension, Judge. But again, I believe that he's been doing much better on probation.
Ms. Elizalde? Can I get your input, please?
I was thinking of a jail commitment, Judge, if you were open to it. I do not see any new charges.
Yeah. We can do 60 days. 60 days, Mr. Parra. Is he working? Are you working, Mr. Esparza?
Yes, ma'am. I don't know if you recall, but I work along with my dad at the company. We have our own construction company.
Is this a true third, Miss Elizalde? Go back.
Just a second, Judge. Yes, Judge, it's a true third.
Well, that's where I am at a 60-day jail commitment. It's a true third. He did, I think, a total of 30. It was a 10 and a 20 last time. So we're going to do 60 days this time. Mr. Parra, you're muted. Yeah.
Your Honor, and of course, I would expect that might not include the 21 days, Judge. Would you be willing to reduce 60 by the 21 days, Your Honor?
It will not, but he works, so I will allow him to do work release. Okay.
Understood.
Okay. So with that, let's get the jail commitment going. I don't know that there's anything else outstanding on him, but with the 60 days, I'll go ahead and close out. I don't even know if there's any motion or anything like that. He's to turn himself in on Monday. Actually, yes, on Monday. So that'll be February 6th. He'll turn himself in at 8 p.m. He'll be released at 5 a.m. Okay.
Understood, Your Honor. Yes.
Okay. All righty. We'll see. We'll also do a status hearing on him, Carla Myrna, in 60 days probation status, just to make sure we're on track, Mr. Parra.
Got it, Judge.
Very much. Thank
Thank
you.
you.
Who's next?
Up on page 16, Judge. Annex, may we have Silva, Rafael Silva?
Good afternoon.
Good afternoon. Hmm.
Is that Silva or Silva, Your Honor?
Should be Silva, I think.
Silva.
Rafael Valenzuela Silva.
Not me.
But if you want to stay on that, I'm just joking, Mr. Hernandez. I was floored. We have two 2014 cases on here. But I figured out why.
Yes, Your Honor.
Annex, do we have Silva?
Yes, Your Honor, he's coming out. He's just next door. He's the
Oh.
locked in. We only have two spaces. That makes
That's
it-
okay. Thank you.
Wait.
While we wait, I was attempting to look at the additional evaluation, and I wasn't able to find that in Odyssey. So Ms. Martinez, I think I had sent a message to Ms. Nieto to see if you all by any chance either had a hard copy or if you could shoot that my way.
Your Honor, I do have the copy if you'd like me to forward it to you real quick.
Sure. This is the Dunham report.
Yes, Your Honor.
I didn't see that one.
Yes, ma'am.
Is that Mr. Silva? Yes?
Yes.
Okay, thank you. Let's go ahead and get started, Mr. Mano.
In cause number 2014-0D04998, State of Texas versus Rafael Valenzuela Silva. Announcement of council, please.
Eliana Elizalde for the state. State is ready.
Alyssa Nava on behalf of Mr. Silva, Your Honor, and we're ready to proceed.
Okay, Mr. Silva.
Probation, Your Honor.
I'm sorry, Ms. Gatto. Mr. Silva is appearing remotely from the jail annex. We're set for a probation status hearing today. Ms. Gatto, what kind of update do you have for me?
Your Honor, I have been in communication with his family. I
Mhm.
worked with Mr. Silva many years and we would get along great. But all of a sudden, he was the type of person that didn't like to stay in homeless shelters. He liked to live in the streets. That he was always like that, but he would always come in and report. And then all of a sudden, back in 2018, he just didn't come in anymore. And then soon enough, he stopped getting my phone calls, receiving my phone calls. His family would usually find him in the streets and take him food or, offer him money or whatnot, but they stopped finding him as well. So we eventually got a bench warrant, Your Honor, and he was picked up on that bench warrant 2 years later on August 11th, 2020. He was placed on the competency list and sent to the 384th. He never went to the state hospital. I was very surprised. He was 2 weeks away from leaving. And they got a report saying that he no longer needed to go. So I spoke to the family as soon as I found out, and they tell me, yeah, we've been seeing him every 2 weeks. He's the same person. I really don't see a change in him. But then I asked, well, can you take him in so that, we can get him back on track? Back on track means get him back into Tacoma services so he can get mental health, get SSI going so he can get his own money. And once he gets his own money, we can put him in a foster home.
Ms. Gatto, I don't mean to interrupt because
Sorry,
I know
Your Honor.
you're engaged and, I guess are on track, but I did review the report and I see that the recommendation is that we take a little bit more time to come up with some type of, I guess I'll call it safety plan, some type of plan so that we are not setting him up for failure. The request is for an additional 2 weeks. I kind of think that might be a little fast, but because it seems like there's a lot of needs here. But I'm happy to come back in 2 weeks. Ms. Gatto, I feel like it's going to be 30 days realistically, to get everything squared away, but I'll go off of your guide. Because I have the same concerns after reading the report and seeing where this case has kind of been. When is he due to term?
In 3 years, Your Honor.
I still have a good chunk of time. Ms. Nava, how are you with 30 days?
Your Honor, I think that's so much better than 2 weeks because I do not want to set him up for failure. And I do think if we get him back into services, well, we just need time to coordinate doing so. If Ms. Gatto can include her email, and that way I can touch base with her and help in any way to make sure that Mr. Silva is getting what he needs or that we can set him up with what he needs.
So what I'm going to do is we're going to do February 28th at 3 p.m. Well, is there a preference for the jail docket or non-jail docket?
I prefer the jail docket so that if there's instructions, you can provide those to him yourself, Your Honor.
Beautiful. So we'll do the 28th at 3 p.m. Mr. Silva, your attorney, probation are all working so we can come up with a good plan, but I'll leave it to your attorney to communicate with you. We're going to come back in 30 days so that hopefully we have enough time to to formulate that, okay? Ms. Nava, thank you for your help. Ms. Caro, thank you very much. We'll come
Thank
back
you,
in
Your
30 days. Thank you.
Thank you.
Thank you, Mr. Silva. Who's next?
Then page 16, Judge.
Mhm.
Annex, may we have Valles, Daniel Valles?
Yeah.
All right, go ahead.
In cause number 2019 0D04292, State of Texas versus Daniel Valles. Announcement of council, please.
Raul King and Rebecca Tarongo for the state of Texas. State is ready. Good afternoon, Your Honor.
Good afternoon.
Good afternoon, Judge Veronica Teresa Lerma on behalf of Mr. Valles.
And Mr. Bias is appearing remotely from the jail annex. We're scheduled for a, I don't even want to call it a final status conference, a status conference today. And we don't have anything until our final hearing plea deadline. How are we doing?
Your Honor, there is a couple of updates I wanted to inform the court. The first one is going to be regarding the motion for discovery that opposing counsel filed regarding the witness Christian Baeza. I believe that was filed
The 20th?
Yes. Just an oral response. I have not filed an actual written response, but I can do so. We have disclosed on March 4th, 2022, all of his criminal history and any addresses that we have. Of course, I will keep updating that addresses if any comes up. As far as the second thing is the email that I received from Ms. Veronica Lerma that was dated December 6, 2022, and I did respond that same day. That was regarding the iCloud. If we can try to send the phone or have iCloud logged in through Apple. I did not receive a response back from Ms. Lerma. And the last update would be the phone extraction at HSI. I was informed by the special agent Antonio Yenes yesterday and today actually that the phone did give an error message. He does not have an explanation to why sometimes these phones give an error message. However, he did to overcome the error message, he would just have to restart the brute force process. So as of right now, there's the 215 days.
So are you basically telling me on the phone it's a restart after we got that error message? Or does it continue? Like is it all the work that's been done, does it have to be redone?
Your Honor, from my understanding from speaking to him, it is a restart, yes. That's all the update from the state, Your Honor.
Okay. So I did see the motion for discovery, unless I feel like when I read it, Ms. Lerma, you were requesting a hearing and that wasn't specifically set today, although it was filed on the 20th. We're 11 days later. It looks like Ms. King's looked at it. Happy to have a hearing on it if there's not some understanding right now.
Well, I think she clarified, Judge, that we have the address. That's the only address they have. Certainly if they pick him up, I believe he has a warrant. They have to let us know that. And I'm sure she's aware of that too.
Okay.
So I guess that's really where we are, just to produce him and continue to produce his information.
Got it.
Regarding the issue on the Apple Cloud, yes, Ms. King did respond to me. Her response included that the family does not know what the complaint, what the Apple iCloud was, what the handle was. So I'm trying to get some answers from Apple to see, can we proceed without knowing, or can you find out what the Apple iCloud handle was? So I have not been able to respond to her on that because I have not gotten an answer definitively from Apple. But we did discuss sending the court a joint motion to order Apple to provide that, but I believe I need to know what her handle was on the phone before I can do that.
Okay. Well,
And Your Honor, if I may, just response I did touch base with the marshals, and as of today, they have not picked up Christian Baeza. There is still that bench warrant out for him because he does have a pending probation case out of the 34th District Court.
Okay. What else, ladies? This is kind
I
of
don't-
like a little bit of a downer of an update. I was hoping to hear that we had actually like broken through the fog. So great.
Yeah.
I do not have you all coming back, period. Until we go to trial. I'm assuming everything else is the same, right? Rec's the same, everything else is the same. So we're gonna see you all in, we're gonna come back in 60 days. Okay, just get us a status. Other than that, if you have something that requires a hearing, if something regarding Mr. Baeza or something else comes up and you all need a hearing, please do not wait because we're on track. That's all I'll say. Okay.
All right, thank you, Judge.
All right, thank you, ladies. Y'all are excused.
Thank you.
Who's next?
Top of page 15, Judge.
Okay.
Annex, may we have Eric Lopez?
That Mr. Lopez?
Yes, ma'am.
Okay, go ahead.
In cause number 2022-0D02364, State of Texas versus Eric Elijah Lopez. Announcement of council, please.
Juliana Elizalde for the state is ready.
Eric Mays on behalf of the defense, Judge, we're ready to proceed.
And Mr. Lopez is appearing remotely from the jail annex. Mr. Mesa, I need to confirm with you and your client that you all are waiving having this plea done in person and are agreeable to do it remotely.
That's correct, Judge, we're waiving it.
Mr. Lopez, you're in agreement to do this plea over Zoom?
Yes, ma'am.
Okay, Mr. Lopez, I can tell you, I may need you to speak a little louder, okay? You can keep your mask on, just turn up the volume a little bit, okay?
All right.
So in fact, we are scheduled for a plea today, Mr. Lopez. So I need to swear you in. Would you raise your right hand, please? If you can, yeah. Do you swear or affirm that any testimony you provide will be the truth and the whole truth?
Yes, Your Honor.
Thank you very much. You can put your hand down. Please state your name and date of birth for the record.
Eric Elijah Lopez, May 9th, 2003.
May 9th, 2003?
Yes.
Okay. Mr. Lopez, I am going to need you to speak a little louder, okay? It's hard to hear you.
Okay.
Okay. All right. So as I mentioned, we are scheduled for a plea today. There are documents that you should have reviewed with your attorney, the first of which is marked as State's Exhibit Number 1. Those are the plea papers in this case. Within that document, you're guaranteed certain rights, including the right to remain silent, the right to trial by jury, the right to counsel, the right to confront and cross-examine witnesses, and the right to call witnesses on your behalf and in your defense. Mr. Lopez, you recall reviewing the plea papers, State's Exhibit Number 1 with your attorney and signing that document.
Yes, ma'am.
Did you understand everything contained within that document?
Yes.
Yes?
Yes.
Mr. Mesa, have you had more than 10 days to prepare a defense in this case?
Yes, we have, Judge.
And did you explain the plea papers to your client?
Yes, we did.
Do you believe he has understood the admonishments, rights, and consequences of giving up these rights by entering his plea today?
I do.
Mr. Lopez, are you satisfied with your attorney's representation of you?
Yes, Your Honor.
Okay, Mr. Mesa, any reason to believe your client is not presently competent to enter his plea?
No, Judge.
Mr. Lopez, have you ever been found mentally incompetent by any court?
No, ma'am.
Ever been examined by a doctor or psychiatrist who has found you mentally ill?
No, ma'am.
So based on your testimony, your attorney's representations, and my observations of you, I'm going to find that you are competent to enter your plea today. Sir, are you a U.S. citizen?
Yes, ma'am.
Where were you born?
El Paso, Texas.
Okay, in this case, you are charged by indictment with 2 counts. The first count is aggravated robbery. The second count is burglary of habitation with the intention to commit another felony. Both of those are first-degree felonies. As to count 1, aggravated robbery, what is your plea? Guilty or not guilty?
Guilty, ma'am.
As to count 2, burglary of habitation, what is your plea? Guilty or not guilty?
Guilty.
Are you making each of your pleas freely and voluntarily?
Yes.
I will find you are making your pleas freely and voluntarily. Ms. Elizalde, would you summarize the evidence, please?
Yes, Judge. Had this case proceeded to trial, the state would have been able to prove beyond a reasonable doubt that on or about the 12th day of June, 2022, and anterior to the presentment of this indictment in the county of El Paso and state of Texas, Eric Elijah Lopez, hereinafter referred to as defendant, paragraph A, did then and there, while in the course of committing theft of property with intent to obtain or maintain control of said property, to wit, a motor vehicle or motor vehicle keys, intentionally or knowingly threaten or place Brian Sanchez in fear of imminent bodily injury or death. And the defendant did then and there use or exhibit a deadly weapon, to wit, a firearm, to wit, a rifle. And it is further presented that the said defendant used and exhibited a deadly weapon, to wit, a firearm, to wit, a rifle, during the commission of and immediate flight from said offense. Paragraph B, did then and there, while in the course of committing theft of property and with the intent to obtain or maintain control of said property, to wit, a motor vehicle keys, intentionally, knowingly, or recklessly cause bodily injury to Brian Sanchez by striking Brian Sanchez with a firearm, to wit, a rifle, about the body, and the defendant did then and there use or exhibit a deadly weapon, to wit, a firearm. And it is further presented that the defendant used and exhibited a deadly weapon, to wit, a firearm, during the commission of an immediate flight from said offense. As to count 2, paragraph A, did then and there, with intent to commit the felony offense of aggravated robbery, enter a habitation without the effective consent of Brian Sanchez, the owner thereof. And it is further presented that the said defendant used and exhibited a deadly weapon, to wit, a firearm, to wit, a shotgun or a pellet rifle, that in the manner of its use and intended use was capable of causing death and serious bodily injury during the commission and immediate flight from said offense. Paragraph B, did then and there intentionally and knowingly enter a habitation without the effective consent of Brian Sanchez, the owner thereof, and attempted to commit or committed the felony offense of aggravated robbery. And it is further presented that said defendant used and exhibited a deadly weapon, to wit, a firearm, to wit, a shotgun, or a pellet rifle, that in the manner of its use and intended use was capable of causing death and serious bodily injury during the commission of and the immediate flight from said offense. At this time, we would ask that the court introduce into the record States Exhibit 1, the plea paper, States Exhibit 2, 39.14.
Any objection, Mr. Mesa?
No objection, Judge.
States 1 and 2 are omitted. What is the plea agreement?
Judge, the plea agreement is 5-year community supervision under the deferred adjudication provisions of the Texas Code of Criminal Procedure. In addition, a $4,000 fine with $2,000 probated. Additionally, 400 hours of community service and curfew, UABA, tax assessment, may not possess any weapons or ammunition, no contact with the complainant, Brian Sanchez, or co-defendants, Jesus Manuel Guerrero, Eileen Hernandez, or German Giovanni Gallegos.
Okay, Mr. Mesa, is that your understanding of the plea agreement?
It is, Your Honor.
Mr. Lopez, is that your understanding as well?
Yes, ma'am.
Understand that the plea agreement is not binding on the court. However, if I were to reject it, I would allow you to withdraw your pleas. If I follow the plea agreement, you may not appeal this case except on matters raised by written motion and ruled on before trial or by permission of the court. The next document I'm going to ask you about is the one-page document entitled The Trial Court Certification of Your Right to Appeal. It is a document that explains your appeal rights. Because this is a plea bargained or negotiated case, you do not have an automatic right of appeal. Mr. Lopez, do you recall reviewing the trial court certification with your attorney and signing that document?
Yes, ma'am.
It was signed by your attorney and signed by the court as well. Finally, the motion for deferred adjudication. Mr. Lopez, do you recall reviewing the motion for deferred adjudication with your attorney and signing that document?
Yes, Your Honor.
Mr. Mesa, have you explained to your client both the benefits and detriments of deferred adjudication?
We did.
Mr. Lopez, do you understand that if you violate a condition of deferred adjudication, the court can proceed to sentence you up to the full range of punishment for these offenses? These are first-degree felonies. You understand that?
Understood.
So are you asking the court to grant you deferred adjudication?
Yes, ma'am.
I will find that there is sufficient evidence to substantiate findings of guilt in this case. However, I will not enter findings of guilt at this time. Instead, I will defer further proceedings and place you on community supervision pursuant to the plea agreement for a period of 5 years. There will be a $4,000 fine. $2,000 of that is probated. 400 hours of community service, curfew from 9 p.m. to 6 a.m. unless you are working or going to school. You are subject to urine and breath analysis testing. You are not to possess any firearms or ammunition. You have no contact with the complainant or any of the co-defendants in this case, and there are deadly weapon findings here. Is there anything further, Ms. Elizalde or Mr. Mesa?
Nothing.
There's one.
Go ahead. Thank you, Ms. Elizalde. Mr. Mesa.
Thank you. Mr. Lopez has been in custody since June 12th of last year. All we ask is that any credit go towards court costs or whatever else it can.
That's fine.
Thank you, Judge. Nothing further.
Mr. Lopez, you better not mess up. You're on deferred probation for 5 years. Are you smiling?
No, ma'am.
All right. We'll see you. Thank you, Mr. Mesa.
Thank you, Your Honor.
Who's next?
Top of page 14, Judge. Annex, may we have Gilbert Bautista?
Yes, sir. Just give me 1 second. Are you?
Bear with me 1 second. Let me look for the report. Go ahead.
In cause number 2020-0D00002, State of Texas versus Gilbert Bautista. Announcement of council, please.
Eliana Elizalde for the state. State is ready.
Good afternoon, Judge. I am here, but for some reason my camera is not on, but I am here.
Oh, you can see your background. That's a fancy trick. All right. Well, I'll count you as here. You've got your camera on, I think. All right. I thought Mr. Bautista is appearing remotely from the jail annex. Did we have an agreement here? He's going to PHRTC, right?
That's correct, Judge, and the misdemeanors have been dismissed.
Okay, perfect. Ms. Carla, send me the modifications to send him to BHRTC.
Yes, Your Honor.
¿Qué más? What else?
I think we were just pending the misdemeanors, but Mr. Stevens did let me know they're dismissed.
Okay.
So,
Mr. Bautista, do your best. Take advantage of the treatment. I know you have voiced on different occasions and have been frustrated that you need the treatment. We're all pulling for you to do well.
Appreciate the honor.
All right. Thank you very much. We'll get the mods and get you going. Great. Who's next?
Bottom of page 15, Judge. Annex, may we have Roacho, Joshua?
Right, yes. Oh.
Judge, if you want me to restart my computer, I'll be happy to do that, but it'll take me 5 minutes.
Are you on this one?
I am.
Let me see. I guess if you want to try, so your client can see you. I see Mr. Huffman. Maybe we can go to another one of the other cases, unless you can do it quickly, Mr. Stevens.
Okay, go ahead with Mr. Huffman and I'll be right back. Thank you.
Okay.
Annex, may we have Martinez, Tobias Martinez?
We'll be right with you, Mr. Rocho. We're gonna take on somebody else because your client, your attorney needs to fix his computer. that you, Mr. Martinez?
Yes, ma'am.
Okay, let's go.
In cause number 2020-0D04875, State of Texas versus Jacob Tobias Martinez. Announcement of council, please.
Eliana Elizalde for the state. State is ready.
Rick Hoffman on behalf of Mr. Martinez, we are ready, Your Honor.
And Mr. Martinez is appearing from the jail annex. We're scheduled for a status conference today, but it looks like this may have been a situation where maybe we hadn't located him. Mr. Huffman?
He's actually been in custody at the Dona Ana.
Oh, okay.
facility, and he's back now.
Okay.
He's been extradited back from the facility.
Okay, do you all know, obviously what I'm gonna do is set you for trial unless you all have some other thing already worked out.
So Judge, the offer right now is probation. The issue is Mr. Tobias lives in Las Cruces and he's doing the drug court out there. I'm not sure how long his probation sentence is out in New Mexico. But he's starting probation out there. I'm still waiting on paperwork from his lawyer. I'm trying to track down the specific terms and conditions of his probation. He's been in custody, Judge, for about a year and 4 or 5 months. So I was thinking maybe we can do like a time served type deal here, assuming that he's in the drug court in New Mexico, rather than start him on probation here and probation over in New Mexico. I just thinking with all that time he's been in jail, maybe we can work something like that out.
Well, I think my job here is to get you a trial date. I can ask Miss Elizalde. She didn't look like she was smiling when you said that. So
I thought it was a good idea.
I don't want to presume that I can read her expressions at this point so early on. But as soon as I saw you say time served, Miss Elizalde did something akin to that. So my question was in that vein, which is, do we have a rec? Just so I know.
So the rec that was given before he was gone was 8 years straight probation, Judge.
Okay.
I mean, he's facing a first degree, so it's a minimum of 5 TDC if I were to give a time rec. Can't he transfer his probation to where, I know that might be an option, so.
If we did probation, and I'll ask Carla to chime in here, the only thing I think becomes like, I'll say difficult, but I don't think it's that big of a deal, is that yes, we can transfer, but it's a process, right? And sometimes that requires that he be here for a period of time. Carla, is that accurate, or is it something different in this case? Sorry, Carla.
I'm so sorry, Judge. I just got kind of the end of it. Are you asking about the transfer?
So on Mr. Martinez, if he were to plead to probation, but he lives in Cruces and is actually doing some other probation in New Mexico, how would we go about, I mean, does he have to live in El Paso for a period of time? How do we do that?
Well, unfortunately, we do have to do the whole process. And as long as, at the time of the plea, he has nothing else holding him, he can go to the interstate office immediately. And considering that he already has some kind of probation out there, maybe there's something that the interstate office can do to expedite it so that he doesn't have to remain in El Paso County up to the 45 days, in other words.
So it's 45 days, more or less, could be expedited because he's already on probation, but none of that is guaranteed. So Mr. Martinez, you need to know that if the state continues to or agrees to offer still probation and you're open to that, and there still might be a process where for our purposes, you would have to be in El Paso County. Okay, and we can't give you a time certain. So with that information, then I'm going to set him for trial in 6 months. Myrna, we need to get him a 6-month trial track because he's in custody. If we're looking at probation, we'll see what the lawyers do to work it out or what can happen. Okay, is the case otherwise ready?
I think what we need to do is to establish contact with CW, Judge. So.
Okay.
Should be.
But then we still have the drug case, right? Yeah, or no?
Yes, we still have the drug case as well.
Okay, so we're gonna do a 6-month trial track. Okay,
Thank you.
all righty. Thank you, Mr. Huffman. Mr. Martinez, who's
Thank you,
next?
Staying with Mr. Hoffman, Judge, on page 15. Annex, may we have Sergio Quesada?
Yes, right up.
All right, go ahead.
In cause number 2022-0D00481, State of Texas versus Sergio Quesada. Announcement of council, please.
Eliana Elizalde for the state. State is ready.
Rick Huffman, on behalf of Mr. Casella, we are ready.
Okay, and we're set for a bond hearing. I believe he's at 100,000, right?
Yes, Your Honor.
Okay, you may proceed, Mr. Huffman.
Thank you, Judge. Mr. Quesada is 18 years old. He is a U.S. citizen from El Paso. Currently lives with his parents, his wife, and his 7-month-old daughter. He works construction, doing cement work. Judge, we were here about 2 weeks ago on a motion to recall the capias. He had some problems on PR bond reporting. It's kind of weird how it went down, Judge. He has 2 cases. So he's been going to court for the other case, and the case that he has a warrant on was a non-arrest from I believe it was September of 2021. That warrant wasn't executed until this past August 10th. So Judge, he immediately got a PR bond from the JMAG, and I don't know. I think there was some miscommunication as far as how he needs to report, what he needs to do on PR bond. There were some other issues with him not having a phone. But anyway, Judge, so we were here a couple weeks ago on a motion to recall the warrants, and the court denied it. And Mr. Quesada turned himself in a couple days later, and so he's been in jail for about a week. Both of these allegations are from over a year ago. The complaining witness is his wife on both cases.
Right.
She doesn't want to prosecute. All reports from her is that that Mr. Quesada is doing well. No issues there. And we're asking the court right now. The offers, it's a probation rec, so we'd like the court to take that into consideration as well. Frankly, Judge, I think we're kind of close, but we're not there yet as far as any deals. I'm hoping for a misdemeanor, Judge. I'll just be frank.
So the issue, if I remember with Mr. Quesada, is that he really hadn't come to court here. And I know there was a lot of back and forth. We checked our logs to see if he had been in, he had not. And so how far apart? Well, what are you requesting on the bond, Mr. Huff?
Well, Judge, given his financial situation, he just doesn't have a lot of money. He's got a young kid. So we're hoping the court will reduce it as far as the court feels comfortable, possibly even a PR bond. He's been out for a while, Judge, and these cases are old. And we're really just trying to negotiate these cases. Which is a lot easier done when he's out, Judge.
Are the 2 cases, Ms. Elizalde, are they otherwise ready to go? They're set in April, so it's a couple months down.
They are, Judge. And we did talk to CW at some point. I'm trying to find the date again. I need to confirm what Mr. Huffman is saying, that she thinks he's doing fine. Because I don't think we don't have a non-pros, and I don't think we ever got a statement that said she does not want to prosecute. So I'm not saying it didn't happen. I'm just saying that would need to be confirmed.
Where was he? Well, I mean, what are we going to do with the living situation, Mr. Huffman? I mean, he's there.
They've been fine, Judge. There's no protective order. He wants to live with his. And I can send that non-pause right now.
Okay, Ms. Elizalde, go ahead.
Judge, I mean, both incidents sound pretty concerning, including she was pregnant at the time. It appears he knew she was pregnant. We have two separate incidents that involve, strangulation. There's photos that show visible bruising on her arms, and all when she's trying to leave him. So I have concerns for the CW. His priors include an assault bodily injury that was 6 months probation, later dismissed as juvenile. We have an unlawful restraint in 2015 and theft in 2017. I'm concerned about the unlawful restraint as well, considering that the allegations in the in the facts is that every time she tries to leave, that's when this happens. And so there is also a portion there where it says he punched her in the stomach, and this is when she was, I believe, 5 months pregnant. He also, as the court knows, was not reporting, or at least that's what I read in the VN, is failed to report that they tried to contact him to his, cell phones and so on. And I think there's a responsibility to reach out as well if there's an obligation to report. So I think the facts are concerning, his record is concerning, and at this point, we would ask that the court consider that. And we would fully object to a straight PR bond if the court is going to modify, but definitely not a full PR bond. I don't think that his history is there.
And Judge, I don't know if you're finished, Ms. Elizalde. If I may respond to that, just briefly, Judge.
Yes.
Okay. So the reason he for the warrant is the reporting. I do not think that's going to be an issue going forward. I think it's clear what he needs to do, and I haven't had since the warrant. I haven't had any issues communicating with him and finding him. I just don't foresee that being an issue going forward, Your Honor.
Okay. For the reasons stated by the state and also the review, I think we had a fairly extensive review last time. I can appreciate that he turned himself in as instructed, but I just can't ignore some of these red flags in terms of the assurances that the court has that he will appear. So what we're going to do is I am going to reduce it. Obviously, 100,000 is up there. We're going to go down to 20,000. Going to be 10,000 cash surety, 10,000 PR. He's going to report monthly. He is to have no offensive contact with the complainant. He may not change his place of residence or leave El Paso County without court permission. Subject to testing, obviously has to appear for court, no new offenses. He's gonna have a curfew from 10 p.m. to 6 a.m. unless he is working. Let me think. No, I'm gonna say use no illegal drug or alcohol. Anything, Miss Elizalde? Anything else?
No,
on the
nothing.
conditions? All right, that's the order. Thank you.
Thank you, Judge.
Who's next?
Annex, may we have Rocho back?
Yes, sir.
There you are, Mr. Stevens.
New computer, Judge.
There you go. Is this the only case? Oh, no. Is this the only? I see there's another case, 2022-0D02638. I don't see it on the docket. So we need to make sure. Yeah, that one wasn't added. You're asking for a bond on that one as well, reduction?
Yes, Your Honor.
Okay, go ahead, Mr. Marufo.
In cause number 2022-0D02641 and 2022-0D02638, State of Texas versus Joshua Rachel. Announcement at council, please.
So hold on. So the cause number is 2640, the first one. Okay, go ahead. Announcements.
Eliana Elizalde for the state. State is ready.
Brett Stevens for Mr. Racho, and we are ready, Your Honor.
And Mr. Racho is appearing from the jail annex. We are scheduled for a bond hearing in 2640. He also filed a bond request in 2638. Mr. Stevens, you may proceed.
Thank you, Your Honor. Judge, we represent Mr. Racho on his 2 felonies. There are quite a few misdemeanors pending. There's 1, 2, 3, 4, 5, 6 other misdemeanors. Some are filed and some aren't. For all of those cases, he's been represented by Ms. Araceli Solis. The newest misdemeanor was from December 2nd, 2022. That one was just filed. And as I said, I don't represent him on that, so I haven't been able to look at Portal, but I did read the affidavit. And the affidavit indicated that this lady, it's the same lady in all of them. She's claiming that he went to her house, asked if he could live with her, and she stuck her head out the door and said no, and that he headbutted her. My client is denying any of that. He denies that he was even around her, near her. But I believe that's the reason that his bonds were revoked. His current bonds on the felonies are at $100,000 each. I think he would be hard pressed to afford much in the way of a surety bond above just a couple of $1,000s. But he's 23, he's born in El Paso. He has an address in El Paso he could live with his mother and little brother. But what he really wants to do is go to Odessa or Midland or Pecos and work in the oil industry there. He apparently has a job waiting for him in Pecos if he was allowed to move there. He has a GED from 2017. He's single, has no children. There's one child with the complaining witness, but that's not my client's son. Although they apparently do have a long-term relationship. There are 1622 issues in this case, and so my client needs to continue with Takumi. And he told me that while he was in jail, he did take an anger management class. So I wanted to make you aware of that.
Thank you. Is that everything?
Yes, ma'am.
All right, Ms. Elizalde, go ahead.
We would object to a PR bond or any modification. This is another case. I find it very concerning. He does have the only history that I could see was juvenile assault in 2015. I don't know the dispo, which probably means it was dismissed, but the facts of the case are concerning. They're all with the same complaining witness. The first one, and I'm looking at specifically 2640, the defendant is going to pick up some personal belongings that were left at the door. She was moving the car. They meet at the front. And he slapped her. He took her keys, causing a laceration on her finger, grabbed her by the hair, dragged her to the couch. He got some scissors and started cutting her hair, and he began to strangle her, then sprayed her with bleach and ran out. And there was visible injuries consistent with that were consistent with the allegations made. As to the other case, what we have is the defendant goes to her home again. He grabs her, causing pain, and she tries to call 911. He yanks the phone out of her hand, causing her nail to break, and he takes something from her purse. When officers get there, they observe a crack approximately 18 inches in the middle of the door frame. The window next to the door was pushed up slightly. There was a blood mark on the door from the victim's broken fingernail when she closed the door. And then the officers observed red and blue bruising on victim's left inner arm. And so essentially we have cooperation, I think, in the strength of the cases and the fact that CW is cooperative. And then he picks up a new case. So I get that Mr. Stevens is representing what his client is telling him, but at some point we have to get to the idea, that this likely did happen, that he is continuing to go to the CW. He, in this case, picked up another charge, but I do not trust that he will follow your orders. I think he's a danger to the community, specifically to this victim. And so I would respectfully ask the court to not grant PR bond or modify.
Okay. Anything else?
No, Your Honor.
Mr. Stevens?
Judge, the only thing I would add is my client is bringing me documents. He's been telling me he's going to be bringing me documents for quite some time, which could help with our case. I don't have anything to present to you now. Some of what Ms. Elizalde indicated, I would disagree with the way that she portrayed it as helping her case, but my client denies all of this.
So the primary concern that the court has is somewhat of what Ms. Elizalde said, which is the basis for the PR violation is that he continues to contact the complaining witness. So being that we have our trial date coming up, the request to reduce the bond is denied. The basis is for the safety of the victim, prior non-compliance. Yeah, no, the bonds are going to stay as is.
Okay, thank you, Judge.
Thank you. Who's next?
Back on page 1, Judge. Annex, may we have Chandler, Daniel Chandler?
Mr. Chandler, is that you?
No.
Okay, let's get started.
In cause number 2022-0D00578, State of Texas versus Daniel Gary Chandler. Announcement of council, please.
Eliana Elizalde for the state. Ready?
Brett Stevens for Mr. Chandler, we're ready, Your Honor.
And Mr. Chandler is appearing remotely from the jail annex. I think we were originally scheduled for final hearing plea deadline, but I understand we're here for a plea. So Mr. Stevens, is it your understanding that your client has waived his appearance in person to conduct this plea?
Yes, Your Honor.
Mr. Chandler, are you in agreement to conduct this plea over this Zoom format?
Yes, ma'am.
Okay, so we're going to get started with your plea. I need to swear you in. If you would raise your right hand, please. Or do you swear or affirm that any testimony you provide will be the truth and the whole truth?
Yes, ma'am.
Thank you very much. You can put your hand down. Would you please state your name and date of birth for the record?
Daniel Gary Chandler, 1974.
Was that 11/19?
Yes, ma'am. November
Yes.
1974.
Thank you, Mr. Chandler. Sometimes we get a little bit of a break in the audio, so it skips. Alrighty, so I'm going to ask you about documents that you should have reviewed with your attorney, the first of which is marked as State's Exhibit number 1. Those are the plea papers in this case. Within that document, you are guaranteed certain rights, including the right to remain silent, the right to trial by jury, the right to counsel, the right to confront and cross-examine witnesses, and the right to call witnesses on your behalf and in your defense. Mr. Chandler, do you recall reviewing State's Exhibit number 1 with your attorney and signing that document?
Yes, I do.
Did you understand everything contained within that document?
Yes, I do.
Mr. Stevens, have you had more than 10 days to prepare a defense in this case?
Yes, Your Honor.
And did you explain the plea papers to your client?
Yes, I did.
Do you believe he has understood the admonishments, rights, and consequences of giving up these rights by entering his plea today?
Yes, Your Honor.
Mr. Chandler, are you satisfied with your attorney's representation of you? You are? Yes? I don't know why the audio is breaking up. It was fine. Yeah, so, okay. Mr. Stevens, any reason to believe your client is not presently competent to enter his plea?
None, Your Honor.
Mr. Chandler, have you ever been found mentally incompetent by any court?
No, I have not.
Ever been examined by a doctor or psychiatrist who has found you mentally ill?
No, I have not.
Okay, so based on your testimony, your attorney's representation, and my observations of you, I'm going to find that you are competent to enter your plea today. Sir, are you a U.S. citizen?
Yes, I am.
Where were you born?
Orange, California.
Where is that?
Orange County, California, in the city of Orange.
Okay, thank you. So in this case, you're charged by indictment with the first-degree felony of aggravated robbery. Is that what it was? I'm sorry, I have two notations here. Is it pleading to the first?
No, the lesser included robbery, Judge.
Okay, that's what I failed to notate. So although it was originally indicted as a first-degree felony, through negotiations, my understanding is you are pleading to the lesser included second-degree offense of robbery. Sir, to that lesser included charge, what is your plea, guilty or not guilty?
Guilty, ma'am.
Are you making your plea freely and voluntarily?
Yes, I am.
I'll find you are making your plea freely and voluntarily. Ms. Elizalde, would you summarize the evidence, please?
Yes, Judge. Had this case proceeded to trial, the state would have been able to prove beyond a reasonable doubt that on or about the 17th day of November 2021 and anterior to the presentment of this indictment in the county of El Paso and state of Texas, Daniel Gary Chandler, hereinafter referred to as defendant, did then and there, while in the course of committing theft of property and with intent to obtain or maintain control of said property, intentionally or knowingly threaten or place Patrick Gauthier in fear of imminent bodily injury or death. And the defendant did then and there use or exhibit a deadly weapon, to wit, a knife, that in the manner of its use and intended use was capable of causing death and serious bodily injury. And it is further presented that the said defendant used and exhibited a deadly weapon, to wit, a knife, during the commission of an immediate flight from said offense. At this point, we would ask the court to admit into the record State's Exhibit 1, the plea papers, and State's Exhibit 2, 39.14 disclosure form.
Any objection?
Judge, I do not have any objection, except that I would like to point out that for our plea agreement, the charge was dropped to robbery, and part of the plea agreement is that there's no finding of a deadly weapon.
Is that the agreement, Ms. Elizalde?
Yes, Your Honor, it is.
Okay, so with that, is that your understanding of the plea agreement, Mr. Stevens?
Yes, Your Honor.
And Mr. Chandler, is that your understanding as well?
Yes, ma'am.
Understand that the plea agreement is not binding on the court. However, if I were to reject it, I would allow you to withdraw your plea. If I follow the plea agreement, you may not appeal this case except on matters raised by written motion and ruled on before trial or by permission of the court. The next document I'm going to ask about is the one-page document entitled The Trial Court Certification of Your Right to Appeal. It is a document that explains your appeal rights. Because this is a plea bargain or negotiated case, you do not have an automatic right of appeal. Chandler, do you recall reviewing the trial court certification with your attorney and signing that document?
Yes, ma'am, I do.
It was signed by your attorney and signed by the court as well. So on your plea of guilty and the evidence introduced, I will accept your plea and at this time find the evidence substantiates your guilt. I will find you guilty of the lesser included offense of robbery, and I will sentence you according to the plea agreement at 2 years confinement in the Texas Department of Criminal Justice State Jail Facility. You will receive credit for any and all time that you have served. Is there anything further, Ms. Elizalde or Mr. Stevens?
Nothing further, Judge, from the state.
No, Your Honor. Thank you very much.
Good luck to you, Mr. Chandler.
Very much, ma'am.
Who's next?
Yeah.
Second on page 14, Judge. Annex, may we have De La Vega?
Yes, sir. Give me 1 second. Vega.
You say it right here. You say it.
Oh. All right, go ahead.
In cause number 2022-0D00351 and 2022-0D00326, State of Texas versus Henry De La Vega. Announcement of council, please.
Eliana Elizalde for the state. State is ready.
Edward Hernandez, Deputy Public Defender, Mental Health Unit, on behalf of Mr. Henry De La Vega, we're ready to proceed, Your Honor.
And Mr. De La Vega is appearing remotely from the jail annex. We are scheduled for a status conference today. I show you all having jury trial specially set, which is why I think I asked for this status conference. We're specially set on the 10th. So how are we doing on this case?
Your Honor, we've reached an agreement and just waiting for the paperwork.
Ms. Elizalde, that sounds great. So if we haven't already forwarded them, please send them to Mr. Hernandez. My hope will be that, Myrna, we're going to need to change that February 7th setting for instead of 10 a.m., 3 p.m., But let me ask you, Mr. Hernandez, before I assume it, are going to be in agreement to conduct that plea over Zoom, or are you requesting to be done in person?
Your Honor, I don't know that it matters. As soon as the paperwork comes in, I will go meet with my client personally and go over it. So he'll know everything beforehand.
Understood, but the court needs to know that we're not going to have any issues if we conduct it at the 3 p.m. docket. In other words, your client has a right to, if he wants to come and do it in person here in the courtroom.
May I address my client directly, Your Honor?
Sure.
Mr. De La Vega, so the plea hearing will be on the 7th. I'll go see you ahead of time as soon as I get the paperwork. Do you want to do it in person in the courtroom or do it over Zoom?
Zoom.
Zoom? Okay.
All right,
So
then
we'll do it by Zoom.
we can do it at the 3 p.m. docket then, Myrna. So just change the time on that. And as long as we have the plea paperwork, Mr. Hernandez, ahead of time, then you'll be good to go.
Yes, Your Honor. As soon as I get it, Mr. De La Vega, I'll go see you and we'll go over it.
All right, thank you.
Thank you very much. Thank you, Mr. Hernandez. Who's
Thank
next?
you, Your Honor. My excuse, Your Honor.
Yes, sir.
That is it for today's docket.
That's everybody? Okay.